Today was day 5 of the Sabarimala hearings before the Supreme Court's 9-judge bench, and here are a few of the most important updates from it. Senior advocate M.R. Venkatesh, appearing for Atman Trust, argued that practices around menstruation, like women voluntarily staying away from temples, are rooted in belief, discipline, and not discrimination. He told the court that in many parts of South India, this is a long-standing, unwritten practice, even within homes, and that it operates as a matter of personal faith. To support this, he invoked Dr. Ambedkar's Constituent Assembly speeches, arguing that he clearly distinguished between untouchability and temporary ritual impurity, and that mixing of the two, as he suggested, happened in the Sabarimala judgment and distorts constitutional intent. M.R. Venkatesh also questioned the very framework courts use, saying terms like religious denomination under Article 26 and religious practice under Article 25 are inherently vague, and in fact borrowed from Western Christian contexts that don't easily fit into India's diverse traditions. He warned that expanding judicial scrutiny, especially through the essential religious practices doctrine, risks pulling core religious practices into the domain of state regulation. In his view, Article 25(2) allows regulation only of secular aspects, not the religious core of religious practices, and any law interfering with essential practices could violate Article 13, Clause 2. This article prevents any law from coming into force that violates your fundamental rights. He even drew an analogy, saying just because people enter the Supreme Court building, they don't get to manage its affairs. Later on, senior advocate Rajiv Dhawan offered his arguments too. He argued that what we often called superstition cannot simply be excluded, because if religion is tested purely on scientific logic, very little of it would survive. He pointed out that courts can only examine whether a belief is genuinely held, not whether it is scientifically provable. But even he acknowledged a limit. There must be a threshold test to ensure that claims of a belief are bona fide, not arbitrary or fabricated. How far can the courts go in examining belief without redefining religion itself? Comment down below your thoughts and keep following LiveLaw to stay updated with the Sabarimala hearings, and visit livelaw.in to stay updated with everything that is law.